All right, ladies and gentlemen, thank you for coming. This is the House Judiciary Committee. Is this National Secretary's Week or something? Assistance?
Yeah,
what?
Yes,
Ladies and gentlemen, today is Professional Assistance Day, or maybe week. However, whichever it is, this committee would not operate without Brandy. It would absolutely. And there's no doubt, I'm sure that there's a lot of people in the State House in her capacity that do a lot of really good work, but I don't deal with them every day, and we don't deal with them as a committee every day. And we absolutely would not, this committee would not run as smoothly, as effectively, and as efficiently. And some of you may say, well, it doesn't particularly run smoothly, efficiently anyway. So just think how bad it would be if we didn't have her. But we are really glad to have her, and we are really thankful and appreciative of all the work that she does for us. So, did I say that just right? You wrote it all down for us. Please call the roll. Let's go. Here.
Wadsworth.
Here.
England. Almond.
Full time.
Bitzel.
Here.
Chestnut. Faulkner.
Here.
McClammy. Pettis.
Here.
Robbins.
Here.
Simpson. Standridge.
Here.
Starnes.
Here.
Stringer.
Here.
Tillman. We have a quorum.
Okay, thanks. We do have a quorum. We got one public hearing. That's Representative Drummond's public hearing dealing with vaping. That's going to be the last thing we take up. I know she's in another committee, and so we're going to give her the opportunity to be here before we go forward, obviously, with our public hearing. So we will start, if we could, with Representative Stringer. Can we go with 287?
You want me to offer it?
Thank you, Mr. Chairman. This is a bill I brought 2 years ago. It's a bill relating to and involving doxing. For everybody that don't know, doxing is where you're taking someone's personal information and putting it out on the internet or putting it out to cause them harm. It has to be with the intent to cause harm for it to be doxing. We've had this happening across the country. It's becoming probably more of a problem than we've seen, from local officers being doxed. And that includes putting the location where they're sitting doing a report or something with intent to cause them harm, or whether it's doxing some of the jurors or judges or prosecutors on certain cases. Last 2 years ago, we passed this bill bipartisan out of the House. It went to the Senate and ran out of time. So at this time, I'll entertain any questions.
Sure. Does anybody got any questions? I remember this bill from a couple of years ago. Does anybody have any questions about it? Yes, sir, Mr. Simpson.
Mr. Chairman, I have an amendment.
Okay, go ahead.
And this was the amendment that was worked upon by the Criminal Subcommittee, also known as the Chris England Subcommittee yesterday. With respect to lines 50 through 53 on page 2, replace the following: photographs or information of the victim's children. What that amendment does is it will remove the work address, phone number, and email address, since those are information that can be readily available anyway. The next amendment will be to replace on lines 55 through 56 on page 2 with any other information that would enable the victim to be harassed, threatened, or harmed. So that would remove the language of located and contacted from it. And also on page 70, line 77 on page 3, where it would change from a Class D felony to a Class C felony.
So just for my clarification, Mr. Simpson, is that one amendment but 3 places, or is it 3 amendments?
One amendment, 3 places.
Okay, one amendment, 3 places. Anybody have any questions for Mr. Simpson concerning the amendment? Seeing none, all in favor of adopting, please say aye.
Aye.
Any opposed? Okay, the amendment is adopted. Mr. Stringer, back to you, the bill as amended.
Yes, sir. At the appropriate time, I'd ask for a favorable report as amended.
Any questions? All right, there's a motion for a favor
Second.
and a second. Any further questions? Okay, all in favor of giving this bill a favorable report as amended, please say aye. Aye. Any opposed? All right, Mr. Stringer, thanks a lot. Favorable
Chairman,
report
members.
as amended. Representative Treadaway, how about House Bill 288? And folks, while he's coming up here, we had a public hearing last week on House Bill 118. House Bill 118 dealt with home inspectors, and the sponsor of that bill has asked us to carry that over, so we are going to do so, okay? We'll carry that over. So if you came expecting to talk about home inspectors, we are not going to do that and didn't want you to. I think we were going to at some point in later in the day. So go ahead, Representative Treadaway, how about House Bill 288?
Thank you, Mr. Chairman, members of the committee. What House Bill 288 does is creates a new section to go after folks who are involved in organized retail crime, which is a $100 billion criminal enterprise. It is a multinational system facilitated by organized crime, syndicates, and cartels, with profits used to facilitate other crimes such as human trafficking, drug trafficking, and terrorism. Many businesses face large revenue losses, limiting employee pay, passing losses of the theft onto the consumer, or just closing down their business. This is an Alabama problem that costs Alabama jobs. This bill would establish the crime of retail theft. The bill would also establish the crime of organized retail theft, where one or more people are involved. I think if anybody's watching the news lately, you're seeing that this type of theft has skyrocketed. It's exploded as far as the cost to consumers and businesses. They're shutting down all over the country. And we're seeing things that we've never seen before. Walmart's, Target's, Whole Foods shutting down. Why? Because they cannot afford the losses. The ones that are staying open are passing those costs on to you. So what this does, there's some important provisions in here. And Mr. Chairman, if it's okay with you, there's folks from the Retail Association that can answer these questions a lot better than I can, and from the DA's Association. But one of the parts I like is the organized retail crime, where folks are working together. You're starting to see these things show up, whether it's clothing or just about every product on eBay or in pawn shops, and they're selling these items at a great loss. So if there's any questions, I try to answer them, or there's folks here that can do a better job than me.
Yes, ma'am. Go ahead.
Can you describe for me exactly just one typical scenario of what happens?
I think we have a great one, if it's okay with the speaker, on the baby formula, which I think is very important to what's going on, and the danger, not only the theft involved, but the danger to children. And if, with your permission,
Sure.
Mr. Chairman.
Yes, ma'am. Go ahead.
Come
Right up here, ma'am.
Chairman, committee members, my name is Ellie Taylor. I'm with the Alabama Grocers Association. This bill is very important to us because of the theft going on within the grocery community. And the number one thing that's stolen in the grocery community is infant formula. So for us, this is a food safety issue. So there was a case about a month ago in Atlanta where they had raided several public stores, stolen over 600 cans of baby formula, and then taken them to another store in Carrollton, Georgia, to sell that infant formula. Now, once that formula leaves our stores, we don't know where it goes. We don't know how it's stored. We don't know if they're putting it in a hot 110-degree warehouse and the product is being adulterated. We don't know where that's going. So for us, this is really important from a food perspective to ensure that the foods that our consumers get are safe and ready to be able to be eaten. So that's the main thing with grocery. Of course, lots of other things are stolen, but that's our number one food safety concern.
Okay. Thank you, ma'am. Ms. Allman, any other questions?
And this is some sort of organized, this isn't just
Yeah, these are people that are working together in a network, and so they're going to multiple stores and they're picketing, and they know, these criminals know what the thresholds are. So right now, under the $500, you know, they know that. So what they're going to do is they're going to go in and steal just under that, but they may, like in Alabama, go to a store in Shelby County, then they may hit Jefferson County, then they may hit Sinclair County, they may hit all different counties. But these thieves are organized, they know what they're doing, they're stealing just under the thresholds so that they don't meet those felony thresholds, and they know what they're doing. It's very organized. And a lot of this money is being tied to terrorism, and they know that's where some of this is going.
Okay. Anyone else have a question? Yes, sir. Go ahead, Mr. England.
Plenty of. All right, this would create the new code section for retail organized theft. Just have some general questions. How many people are required to participate in a conspiracy for retail theft in order to create or to violate this code section?
That's a great question. That's why the DA's Association is here. But it's my understanding more than 2 people were involved. And another aspect of it, and you may have this question coming up, the jurisdiction. If there's an individual that's up in Baldwin County telling somebody up in Jefferson County, yeah, get these items, we're going to be able to sell them online or sell them in my pawn shop. We're going to be able to charge the person either in that jurisdiction or Jefferson County, in either one. And they've been falling through the loops. And what you were talking about, just staying under the threshold, there's a cumulative effect here now that you can go after them and charge them with a felony. You know, in those type scenarios. But to answer your question, if it's okay with the chairman, Barry Matz with the DA's. Oh, I'm sorry, Jeff's here. With the DA's Association?
Please identify yourself, sir.
Yes, sir. Good afternoon. My name is Jeff Bradley. I'm the General Counsel for the Office of Prosecution Services. Representative England, if you, the new crime that you're talking about, 13A8226, subparagraph A, requires one or more other persons in association with whoever the defendant is. So it would require at least 2 people, but it could be more.
To arrest someone for this offense, does the other person involved have to be arrested as well?
No, sir, they do not. Okay. And we got that provision. It's the very similar provision to what is in the receiving stolen property statutes that don't specify that the person that might also be involved in the stealing or whatever, that they don't also have to be charged or convicted in order to convict the person who's actually in possession of it. We stole that idea essentially, for lack of a better description, from the receiving stolen property statutes.
Okay. Is there a value threshold?
For the organized retail theft, no, there's not a value threshold. There is a value threshold for the retail theft, which mirrors the theft statutes, and there is $0 to $500 is a Class A misdemeanor, $500 to $2,500 is a Class C felony, and then $2,500 and above is a Class B felony. It mirrors the thresholds for the theft statute.
So if you and I work together to steal a Snickers bar, that could be a Class B felony.
Theoretically, it could, but because the theft statutes are already there, the officers, magistrates, judges, prosecutors would still have the discretion to... Stop.
The answer to that question is yes. Correct?
Theoretically, yes.
So you and I work together to steal something that's worth less than $1 could end up with us being Class B felons.
Theoretically, yes.
Okay. And I noticed that and I mean, that should be offensive to everybody in here, but it might not be. There may be people who are very comfortable with the range of punishment on a Class B felon if 2 people work together to shoplift. But what is the current procedure or when somebody shoplifts from a major retail association? What does the owner have to do?
Well, Depending on the facts and circumstances, they would typically call the police, make a report. They would, if it was a misdemeanor, they would typically be advised on the process to go to either municipal court or state court. If it was a felony, typically the police agency would investigate it, and if they found probable cause, they would approach a magistrate themselves, and they would apply for a warrant for arrest for theft of property.
But I'm sorry, but on a theft of property, shoplifting from any store in the state of Alabama, if nobody's there to see it, right? Generally speaking, the store owner would have to go seek a warrant, right?
Not necessarily, no, sir.
But so how do they get the warrant?
Well, like I said, depending on whether it's a misdemeanor or a felony, if it's a felony, typically the police agencies will investigate.
I'm talking about shoplifting misdemeanor.
A shoplifting misdemeanor. Okay. Typically, at least in my experience, the police would investigate it, write a report, and they would provide information to the store owner or manager, some representative of the store, who would then approach either the city magistrate if there was a municipal court or.
I just said that. You just disagree with me. So the store owner has to go sign a warrant, correct? On a misdemeanor shoplifting.
Typically, if the police are not present when it happens, yes, sir.
Okay.
And I apologize if I misunderstood.
That was specifically the question I asked you. So if as a store owner, the ability to prosecute someone or not prosecute someone is generally left up to the discretion of the owner. So the fact that somebody who steals from Walmart or any retail organization or any retail or store is not prosecuted is generally speaking a decision that the retailer has made, right?
I would disagree with that.
So, I mean, I know when I used to prosecute, and loss prevention officer would come down to the courthouse, and they get tired of coming because they would say that a Class A misdemeanor is just not enough time, not to justify my time. So many of these stores started writing some of this theft off. But my concern is, while a Class A misdemeanor may not be a motivation for it, a Class B felony certainly will be. And what you said was, I mean, seriously, what you said was 2 people could go to jail could be arrested for a Class B felony for shoplifting, right? But you also said, and it's also in the bill, that the other person doesn't have to be arrested. So technically, one person, as long as there's any information here to indicate that they may have talked to somebody else, one person who shoplifts under this bill could be arrested as a Class B felon. I mean, I get business influence and prosecuting and all that kind of stuff, but this is kind of going wild a little bit. That's kind of going too far. So, I mean, and I'm not completely adverse to the concept, because I understand that there is, and I think the previous speaker said that baby formula was being used to fund terrorism. That's new one on me, but I've seen on TV the organized mobs that go into buildings and ransack stores. But this bill would be the king of unintended consequences, as store owners would use it to pretend to send a message to a shoplifter that if you shoplift here, we're going to get you arrested for a Class B felony. I think for me, and I may be speaking for myself, but that specific code section, proposed code section, needs to be at least some sort of threshold put in it or amended out of it, because that's just too dangerous. It's too dangerous.
Mr. Madison, this gentleman was speaking. Let's let him. I think you asked him to come on.
Yes, sir.
And let's let him continue. All right, just a second. You through, Mr. Aaron? Mr. Robbins?
I have a couple questions. One is, in reading the code, we already have theft of property, which is 13A83, which is basically exactly what we already have here, or what you're proposing. So I'm kind of curious, is what's the point in this bill if we already have a theft of property statute on the books?
Well, it is slightly different than the theft of property. There are additional elements under this that it has to be retail property from a retail merchant, where the regular theft statutes would apply to if somebody stole something from me individually, for instance.
Right, but it would still count for retail, right? So if I stole from a retail store,
No, sir.
I could still be charged for theft of property if I stole $2,500 worth of goods from a retail store.
If it's from a retail store, yes,
Right.
there would still be that discretion to be able to charge under either this statute or the regular theft statute.
Right, so then why create this statute if we already have a statute that is a vehicle a prosecutor could use?
The idea here is to kind of address the issue a little bit better than what the normal theft statutes currently do. What a lot is going on with, as we heard about the baby formula, there's a number of other things in my career. I've seen this with televisions, iPhones, all different kinds of things. You see on the news these smash and grab operations that come in and they grab tons of stuff and they run out. And the idea behind this is to give the police, the prosecutors, the state, kind of some additional tools to try to deal with that situation.
I mean, I'm looking right now at just what would be 13A8-223, and I'm comparing it to 13A83, and it's pretty much identical. It's theft of which exceeds $2,500 in value of any property, which is A1. And then you have a 180-day period for the aggregate value of $1,000, which is already in the statute. And that's a Class B felony as well. So, I mean, basically we're creating a new statute here that is identical to a statute we already have. So why create this new statute, really, if we already have that vehicle?
Well, again, it's slightly different because this statute, and it kind of defines really what the offenses are in the previous section, and what constitutes the retail theft. It's all those different activities that we're seeing associated with these smash and grabs, these large groups that are coming in and stealing, those kinds of things. So primarily the difference would be in how you can commit the offense. If you look at 13A8-222, that is lists all the different ways that you can do this. And these are all the different ways that in the real world, we're seeing folks come in, and these are the ways they are doing this in order to steal vast quantities of cell phones or televisions or whatever the product may be. So if you look at those, I believe there's 10 different ways under 13A8-222. Those are the different ways that you can commit retail theft. And if you do one of those activities and it's from a retail merchant of retail merchandise, that's when it would qualify for this. So the idea is under 222. That's where the crime is defined, and that's what we're trying to address.
Right. But if, let's say, someone did, as you said, a smash and grab, and they stole a bunch of cell phones, would they not already break a statute that we already have on the books for theft, and could they not be charged now for theft if they did a smash and grab?
Yes, sir, they could.
So that just brings me back to my point: is why I guess I just don't see the point in it if we already have statute that allow you to prosecute somebody.
Sure, and like I said, it's to try to address the issue with a more pointed set of definitions, essentially, is what the idea
is. Mr. Chairman, I've got to be honest. I have been fully supportive of this bill. Some of the issues that have been brought up today, two people walking in and stealing baby formula, that the baby formula has just thrown a wrench in this whole process. If a mother and a father are starving and they come in to steal baby formula to feed a starving baby, we've set it up now to where that would be a Class B felony. I really think, Mr. Chairman, I think this bill needs some work. And I would like to see this bill go to the criminal subcommittee and see if we can work some stuff out.
Any objection?
No objection.
Okay, then I will send this bill to the criminal subcommittee, and Mr. Wadsworth, that's you. So we'll certainly let you do it. I tell you this, I would like to, let's try to get it worked out. Let's try to get this back on next week.
Yes, sir, Mr. Chairman. Let me say this, Representative England and Simpson brought up some really good issues and concerns, and there's enough lawyers on this committee that if you can help us, and the state of Florida has something similar. This is a major problem in this country, and if we can get it in there, work on it right, and actually target the individuals we're trying to target, otherwise, we're going to have these stores closing down all around us in all these communities. So I think we know what we're trying to get here, but with a little help with the committee, I concur with that.
What you're looking, if I'm not mistaken, you're really not looking for the people that are stealing Snicker bars. You're looking for the people that are stealing thousands and thousands of Snicker bars.
That's right. And we need to find some type of language to deal with that. But they're going to go in, if you set a threshold, understand they're going to go in multiple times over and over and over. And each incident is a separate misdemeanor. And so we're trying to avoid that so we can work together. And I'll be glad to show up anytime the subcommittee's in place.
Yeah, I just want to say I appreciate you saying that, Representative Treadway, and I'm a co-sponsor of this bill for the reasons that I think are very valid in the intent to do this. And that's why I co-sponsored the bill with you, is I think it's what we're doing is good here. I also see some of the issues that possibly regarding values with relating to organized retail theft as opposed to regular retail theft. So I think with some simple tweaks, this can be a really good bill. And but I'm for the bill in concept and what you're trying to do.
Appreciate it. Thank you.
Okay, criminal subcommittee, HB 190, Mr. Wadsworth.
Thank you, Mr. Chairman and body. HB 190 is a sales tax, retail sales tax bill, and I had in our last meeting I explained some. In Alabama, there's two methods to sell when people don't pay their property taxes that counties can recover their property taxes. One is called the lien sale method, and the other is this tax sale method here. 41 counties right now have adopted the lien sale method. This bill has nothing to do with any of the liens that have been sold. If property have been previously sold in those counties under the tax sale method, then it would have some application. What this bill does, and it is as a result of the Reciproc case that came down, if a person purchases and does not pay their property taxes, and then somebody pays the property tax for 3 years, and then they get what they call a tax sale deed. Once they get that tax sale deed, that's where this issue comes into play. It's called a judicial redemption. Under Alabama law, in the past, there's several ways that a landowner could redeem. He could redeem within 3 years if it's a property that is the owner is occupied, the new owner is occupied. If it's vacant land, they could have up to 10 years to do it. If the landowner is currently living on the property, they have really an unlimited right to redeem the taxes. But there was a case that came down 2 years ago called Reciproc, and what that said is if someone buys a piece of property at the tax sale, pays the property taxes, or pays some overage, that if they don't file a suit to quiet title within 3 years from the date they get their tax sale deed, then by operation of law, this land reverts back to the original owner who did not pay the taxes. They do not have a lien for any taxes that they've paid. Further, they do not have any type of lien for any type of overage. Right now, based on this new case that's been out there, there is no way to quiet title on a piece of property that that has been sold at a tax sale unless the new owner files suit to what they call quiet title to that property. And what this does, it reverts back. If they don't do that, it reverts back to the person that originally didn't pay the tax, and you go through that same process again. And basically what this does is says that there's a 6-year period they can redeem their taxes. After a 6-year period, one, it does not automatically revert by operational law to the original owner, but they have 6 years to pay the taxes the original owner does, and then they redeem the property and get it back. But if they don't, then that's like a statute of limitations to prevent that piece of property from, it's a statute of limitations, and the prior owner can't redeem it then. But the purpose of this is an ALI bill. It was to correct this tax sale issue. When you have property out there that owners buy at tax sale, they sit on it, nobody's quieted title, and then it goes back by operational law. And to be frank, the new tax sale owner wouldn't even know, if they aren't familiar with that case, they would not know it actually went back to the prior owner. But that's the essence of the bill.
We took this up initially, there was a couple of amendments. There was an amendment, and which was adopted. So we can go forward.
And
those amendments continuing to be with this, to go with this bill, then there's no.
it might be, Ms. Robbins may have an amendment.
I have an amendment so the amendment is on page 3. We're striking line 82 through line 90. It's eliminating the procedure where the redeeming party would have to pay into the court the redemption amount up front, and if they fail to do that, that could cause their redemptive action to be dismissed. So we're just eliminating that procedure. So the judge at the end of the case would set what the redemption amount was, and that way, my logic is if a case drags on for 2 years, it's not fair for the redeeming party to not get any interest, but the person holding the tax deed to be getting interest for all the time.
And that's a friendly amendment.
I move for a second the amendment.
Thanks. This is okay. And does everybody understand? The amendment's just not requiring that individual to pay into court an amount of money, that amount of money to be determined at the end of the hearing.
That's correct.
All right. That's what I understood also. There's a motion and a second to adopt that amendment. Are there any discussions on the amendment? All in favor say aye.
Aye.
Okay. Any opposed? It's amended. All right, Mr. Wadsworth, your bill is back to you as amended now twice.
Okay. If it's appropriate.
Okay. Mr. Faulkner's got a question or a comment or something.
Yeah. So this was referred to the Civil Subcommittee, and we had a meeting, Representative Wadsworth, as you know, with the counties and their representative, and I understand that representative is out today due to a family death. And the realtors were also opposed to the bill originally. We had that meeting, and could you update me on the status of what they have given back to you?
Well, David Kimberly was involved in that negotiation. Could I?
That'd be great.
Let him speak, if that's all right.
You could just update us.
Chairman. Could I bring David Kimberly up because he was involved in that part of it?
Mr. Kimberly, certainly speak to this.
All right, thank you. Monday, the group you're speaking about submitted a proposal to add a subsection B to the current statute stating that a bill to quiet title is not a recovery of real estate or a redemption as defined under the statute. Then that was the essence of the amendment.
Okay.
We responded with adding a subsection B that basically just dealt with the real prop issue, leaving the rest of the statute intact.
So,
and that's the extent of any movement by.
Okay. With that amendment, then would they be in agreement with the bill?
Have not.
And I was wondering how Representative Wadsworth.
Have not heard.
If they were, would you be willing to accept that amendment on the floor, or have you seen the amendment?
I haven't seen the amendment. I would be willing to consider it, but my understanding is it did not solve the issue of that case. So, and the property still transferred back by operation of law if the owner did not file, the new owner did not file a petition to quiet title. And that's the issue of this case, of this bill, is trying to solve that issue.
I got you. I just want to make sure you'd be willing to work with them if that amendment, even if you don't see the significance of it. Okay.
I would.
All right. Thank you, sir. Thank you, Mr. Chairman.
Yeah, I've got a question. Our comment and a question, I guess, but my understanding is, just from hearing from my local officials, that they still got concerns, with the bill, and that that hadn't been worked out. And I don't know if you've got any more conversations with them.
It's my understanding, and I think probably this is the main part. The 41 of the 67 counties have gone to the lien sale method. And I think, I may be incorrect, but I think that group is wanting the entire state to go to the lien sale method. However, this bill doesn't affect the lien sale. It affects the property that has the counties that have used the tax sale method, and any properties that have been sold through the tax sale method. That case still affects those.
Okay. Well, it just appears from the last I've heard that the counties and the local officials, tax officials, still have issues with it. And I'm not sure exactly where that is, but also I don't know, I know that the realtors also had some concerns. Do you know if those have been alleviated?
I don't know that, but I will say this: under both methods, I think part of the issue was they felt like they maybe having to go to court. But I will say this: under the lien sale method, if you purchase a lien, you got to do a suit for ejectment, and you got to file suit to quiet title under that method, and also under this tax sale method. Under that case, you've got to file suit to quiet title also under that method, and a suit for ejectment if they're still on it.
I know that. It's a complicated issue.
It is.
And sitting through the subcommittee, it's very complicated and complex, and I appreciate your work on it. I just feel uncomfortable unless unless I'm a little more comfortable with how our local officials, because they have to deal with it every day. I've been there, and you have to deal with it every day as a local official. And so I would, I feel personally uncomfortable with it going forward.
And I'll say my home county has been under the tax sale method, has been under the lien method for the last 2 years. And this bill doesn't impact that in my home county. It just affects property that's sold through the tax sale method.
Thank you.
Okay, thank you.
Mr. Standers, let me ask you something. I want you to be as comfortable with this as you can, as I do everybody on this committee. This is this without question is a difficult issue because the law is so difficult to understand, so convoluted. And now we've adopted, or we have several of our counties that have gone to a lien sale, and lien is really nothing in the world but a judgment that ends up being sold because the taxes were not paid, as opposed to the procurement of a tax deed that is given if it's done this other way. Is that pretty much right, Mr. Wadsworth?
That's correct. Under both methods, you've got to file suit to quiet title.
So I guess my question to you, Mr. Standridge, or to anyone else on this committee, is: are you comfortable going forward with this today, or do you want to wait a week? Or y'all tell me what you want to do, because here's the deal: I am sympathetic with what Representative Wadsworth is saying, and when we have a Supreme Court ruling.
Court of Civil Appeals.
Okay, Court of Civil appellate level. How about
Yeah.
that? An appellate level ruling that is the law. You know, until such time as it is reversed or overturned, it's the law. And I think it's important that we address the issue that they brought, you know, that they said, they basically said to the legislature, you've got a real problem here and y'all need to look at it. And I think we do. And I don't want to wait a year to look at it. I don't mind if we want to wait a week. I don't mind that. But I do think that I'm sympathetic with what Tim is saying in that a resolution needs to come forward with as we sell these tax sale property, we need to make sure that we have a methodology by which people can go forward in clearing that title. We don't like dead land. We don't like, you know, land that is absolutely unusable in Alabama. That's just, well, see, David, you're nodding. You understand that from your time as a probate judge. But by the same token, if you think you could get comfortable in it in a week, fine. But I'm not willing to go for long periods of time because I do think that the issue that he's raising is a real issue in these tax sales.
And I'll mention this, it's an ALI bill that is designed solely to correct, to fix that case.
I'll answer your question, Mr. Chairman. I'm not comfortable with it today. I can't speak for the other committees just because I have to depend on my local officials that have to work with whatever law we do every day. And I've worked hand in hand with them as a probate judge with those tax officials and doing it. And they appear to still have serious concerns about it. I do understand that the issue's got merit, and I do want it fixed.
Have you talked to, how do y'all do it in Boyd County? Do you know?
It's tax sale.
So you still do the tax sale?
It is at this point.
It's okay.
Yes.
So that's the way Judge Green does his.
Well, it's revenue commissioner.
Okay, I'm sorry.
It's revenue commissioner.
And I'll say this.
In our county, but I do want it resolved. I understand the issue, and I've got a lot of respect for the work that's been done. It's very complicated. So, but I just can't support it today. But, you know, whatever the committee wants to do is fine. I just would like to be worked out a little bit better before, so we could all be on the same page.
Yes, sir, Mr. Faulkner.
Yeah, so look, I sat through that subcommittee meeting, and my only point was I was trying to, I think, is Abby here by chance with the counties? Because I felt they both weighed in. The counties were present, had speakers there, and so did the realtors. And they raised, and they were going to try, but we found in that subcommittee there was a path forward, and it was just agreeing on some verbiage. And so, Mr. Chairman, with your permission, could we ask Abby from the counties to just give us where they are on that? I just want to make sure everybody's voice got into this.
Yes, Mr. Chairman, Abby Fitzpatrick with the Association of County Commissions. I was not in that meeting. I am privy to the back and forth. From my knowledge, we have presented an amendment. We were sent back some details. We were told that that would not work. We've gone back and forth a couple of times, and it seems like now we are still trying to find a path forward, but nothing has been able to be worked out between the parties. So that is where we are now.
Any more questions, Mr. Faulkner? I got one, man, before you sit down. Hank.
Well, I mean, that's my thing is I want to move forward too. This is not, I'm not trying to stall this. It's an ALI bill. I respect all the work that's gone in on it. I want it to move forward. I think there is a path forward, and it's either, you know, if we put it off 1 week, or we, you know, Mr. Wadsworth's willing to continue to work with between now and the time it may arrive on the floor. But
Ms. Fitzpatrick, let me ask you something. Do you see this, Ms. Fitzpatrick, do you see this, this situation with the tax sale and the reversion and these things that I've heard y'all talk about? Do you see that as an issue that we absolutely need to address, since the court apparently put it back in our lap?
As you know, it's a very, very complicated issue. We definitely do still need more time to try and figure out how we can be okay with this legislation. We are hoping in sometime in the very, very near future that we can, transition to the tax liens. It is much easier. It is much more efficient than the tax sales. And so, yes, definitely we have issues with the tax sale process, but we're still trying to work through that so that we can get a path forward. We think that is possible, but like I said, hopefully we will transition away from the tax sales here soon.
Mr. Wadsworth.
I do want to ask her
Sure.
one question. Would I be correct in saying that this bill has no impact on the tax lien position?
Yes, that is correct. It does not affect the tax lien.
And
So those counties that operate under the tax lien, this doesn't matter to them.
Well, if they still have tax sale property on the books, then yes, it would. But it does not affect that new process, no.
Okay.
And I do I've done, this is a ALI bill that's brought to me, but I will say this, I've had a bank bring me a title as a tax sale deed, and I had to send back to him and say, I cannot give you good title of this property. It is not merchantable title. And so they cannot go forward with that transactional loan.
All right, Mr. Wadsworth, are you willing to work with them before it gets to the floor, or do you think we can do this? If we put it off a week, can we get it amended in such a manner that we can go forward without that?
I'm willing to work with them.
So you'd rather go forward today?
I'd rather go forward with them, and but I'm gonna ask David first.
That's right.
Yeah.
Go talk to your lawyer, Mr. Wadsworth. I understand.
Judge, Chairman.
I do that on a regular basis.
Judge,
I got you. That makes sense to me.
Judge,
yes, sir.
The only request that I have is if we do go forward and we do not do a committee substitute, but we do a floor substitute, Mr. Wadsworth, would you promise to this committee that you will get a copy to Representative Hall prior to it going on the floor?
She's three seats down from me, and I do it every single time.
Representative Wadsworth, Mr. Chairman.
Yes, sir, please.
Representative Wadsworth, would you consider putting this off 1 week so we can get all these parties, make sure everybody's together, and then I think hopefully...
I'm fine with that. I have to talk to my lawyer, so...
And we'll do that. We'll put it off 1 week. But for those of you out here, I understand this is sort of an obscure part of the law. And unless you deal with it, you think, what are you spending all this time? But if you've ever dealt with a tax sale, and I've dealt with a few, they are confusing when you read the statute and then when you read the appellate level decisions that interpret that statute. So I think ALI did the right thing in trying to attack this or try to get this fixed. But, okay, we'll put it off 1 week and we'll go from there.
Okay, thank you.
Mm-hmm. Mr. Wadsworth, let me ask you, while you're down there, do you want, since you're doing such a great job, do you want to talk about this what about this 267, this other one?
I'd rather come back after that.
I don't blame you. I got you. Yes, sir. It makes sense. Mr. England?
All right, thank you for the recognition, Mr. Chair. I have two bills, House Bill 229 and 228. I'll start with, I think the first one's 229. I have to say there's some really honest effort being done on House Bill 229 that I think will result in a bill that is a little easier for more people to support. In that spirit, I want to give that bill some more time to work. Representative Betzold specifically has, I think, some really good ideas, and he's been talking to a bunch of people. I know several individuals asked me about the AG's office, and I'm also working very hard with them to figure out if there's some common ground there too. And I hope to have and also getting wise counsel from Bennett Wright about the impact on our prison system. so I can give you better numbers on those as well. So I'm going to ask that House Bill 229 be carried over until next week, and hopefully when we come back, I'll have a different and a better version of the legislation for everyone to consider.
Thank you. Okay, 229 will be carried over for a week. Ladies and gentlemen, I want to introduce you before we get going. This is Judge Phil C. And Judge C is from St. Clair County. He's our presiding circuit judge, and we are very, very happy to have him in our committee meeting today.
Are y'all friends?
On occasion.
I'll say, do you know him? You would know just how much he appreciated what you just did to him. He's going to tell you about it when we're done.
I hear you, Mr. England. I got you. 228.
So now we're on 228.
Yes, sir.
Very, very, very spirited subcommittee meeting on that bill yesterday. And I discovered that, there's potentially some opposition to it. But with that in mind, what I'm offering to the committee today, because there were several amendments that were offered to the bill. So one of the things that I haven't really heard any opposition to was one component of House Bill 228 that's basically an inmate shall be eligible to virtually attend his or her parole hearing. And what I'm offering to y'all today is to eliminate every part of House Bill 228 with the exception of virtual appearance. There's a substitute sitting in front of you, and that substitute would become the bill, and it would basically say an inmate shall be eligible to virtually attend his or her parole hearing.
Does everyone have a copy of the sub?
Yeah.
The whole bill's gone, but that.
Yeah, good work, Faulkner.
That's it. Yes, the answer to your question, Mr. Faulkner, is yes. The whole bill is gone with the exception of the ability for the inmate to either personally or virtually attend the hearing. So that's the sub. Is there a motion? Let's do this way. Is there a motion to adopt the sub? So moved. All right, there's a motion to adopt the sub. Is there a second?
Second.
Thanks. Is there any discussion on whether or not we adopt it?
Just going to draw the attention that Representative England and I have worked together already today, and we're still working together. And I was going to make the motion to adopt the sub, but that's
You may. Thank you. There's a motion all right, there's a motion and a second to adopt the sub. All in favor say aye. Aye. Any opposed? Ma'am. Any questions on the sub?
Yes.
Yes, go ahead.
Okay, well, it was a quick read.
See, the worst thing you can do in the legislature, and for new members too, don't do short bills, because everybody can read them.
Well, it is a quick read. So, Chris, where is this, I assume, Cam Ward, pardon and paroles, you have run this by Director Ward? And have you run it by anybody else? Of this sub?
As far as I know, they've have indicated to me in the past, and now that they have the ability to do it because of COVID.
To do virtual
hearings, and honestly, if this became an issue, you could even put by a certain date if we receive feedback that says that we are currently incapable of doing it. But from what I understand, they are currently, both the Department of Corrections and the Bureau of Pardons and Parole has the infrastructure in place to do this now.
Okay, and they have any objection to doing this?
No.
Okay, yeah. All right.
So is there a motion to give the sub a favorable report?
So moved.
Thank you. Is there a second to that? Thank you. There's a motion and a second to give the sub a favorable report. Is there any discussion? All in favor say aye.
Aye.
Any opposed? Okay. Thank you, Mr. England. You get a favorable report on your sub.
Mr. Chair and members.
Tim, you want to go? You want to? Yeah. Right. The next bill is 267. Another ALI bill.
Thank you, Mr. Chairman and body. As we all know, this bill front and back is actually the bill, and this in blue is actually the summary of the bill. And it's not as complicated as it looks, but it appears to be more complicated. But I will tell you this: we met with 4 or 5 of the members of the ALI committee who originally drafted this bill. In addition, this bill really deals just with nonprofits. We're amending in the past, we have amended the LLC statute, we've amended the corporation statute, we've amended other parts. And what this does, this changes the Alabama Nonprofit Corporation Act, and that's what this is about. And basically what it means is this bill would be effective January 1st, 2024, and that we've had a situation where a lot of nonprofits are having to incorporate in other areas like Delaware or Nevada. And what this does, this makes it part of the Model Act so that they can then just go ahead and incorporate it into Alabama. This applies effective January, if you have an entity that's formed, a nonprofit, after January 1st, 2024, they have to comply with the act. If you have an entity that was formed prior to January 1st, 2024, they are not subject to the act until January 1st, 2025. Then they become subject to the act. The issue then becomes, well, all the nonprofits have to change all their paperwork that they have. The answer to that is they do not. Because if you have an entity that has been formed prior to January 1st, 2024, their bylaws, their articles of incorporation are what they go by. But if they turn around after January 1st, 2025 and make changes to that, then they would have to then look to that statute and make sure it complies with the statute. And you also have, if you have a corporation that was formed prior to January 1st, 2024 that wants to be subject to this act, then they can adopt it and they'll be in compliance. But basically, it sets forth methods of communication. Like your directors have always got to be present or virtually, because they cannot appear, they have to appear either virtually or or being in person. It sets up a means, if you, for example, in Alabama, if you have a corporation that issued, say, 1,000 shares of stock in their articles, but by mistake they've issued 1,500 shares. To correct that, they would have to go back to court and file a petition in court to through a court system to correct that. This bill under this statute allows mistakes that have been made through the corporations to ratify those mistakes by just having the board of directors meet, and if it requires the members to meet, they meet and make those changes without having to go through the court system to do that. This bill allows for transmission of notices electronically. That's not allowed in the past, and that there's a provision. Right now, if you have a member of the board of director that is not a paid member, he actually is exempt under Alabama law. That continues that. Nothing changes on that. But those are essentially, and there was an issue of whether or not board of directors have to be staggered or have to be all at one time. That corrects that. It allows them to make their own decision. But any nonprofit that's in existence right now, before January 1st, 2024, whatever they did in their original bylaws, that is what they follow. If whatever they did in their original articles of incorporation, that is what they follow on that. That does not change any of that. It revises the method of removing directors, and there's just a whole series of things that to make it easier for nonprofits to operate on that. And when we met with the yesterday with the members of the committee that actually adopted this, they explained all the provisions, and then the members of the nonprofit that operate these nonprofits, they actually met and they were able to ask questions to see what impact it would have. And as a result of that, I think there was one amendment that was going to be added, and I think y'all got a copy of that amendment. And what it was is just to whatever the current immunity is, it just codifies whatever the current immunity is, it stays the same. Whatever the duties, it stays the same on that board of directors have. They didn't want some type of change in law about the liability of the members of the board of directors. It just codifies whatever exists now, so a judge can look at that particular issue and then say, hey, it says it stays the same.
Are you offering this amendment?
I am.
Does everyone have a copy of it? Mr. Simpson, do you have a question?
I do. I need to abstain from this bill or voting on this bill and I need that for the record. My wife runs a nonprofit, so I'd prefer to have that officially noted.
Okay, thank you. I appreciate that. All right, if everyone has a copy of the amendment, is there a motion to adopt the amendment?
So moved.
Is there a second? Second. Thank you. All right, is there any questions concerning this amendment? Seeing none, all in favor of adopting the amendment, please say aye.
Aye.
Any opposed? And it's adopted, so Mr. Wadsworth, the bill is back to you as amended.
It also, I'll just mention this one thing. Right now, under the law, it takes 1/20th of the members in a nonprofit to ask for a special session. This eliminates that requirement because most of the time you can't get enough members to have a quorum. It also allows nonprofits to have members and also allows nonprofits to not have and be a non-member nonprofit corporation also. And if there's not any other questions, or if there's any questions, I'd be happy to answer, but if there's not any questions.
Then I'm going to take it that you're making a motion to give this bill a favorable report.
I am.
Thank you. There's a motion and a second to give this bill a favorable report as amended. Are there any questions, any further questions from the body? Seeing none, all in favor say aye.
Aye.
Any opposed? Thank you.
Thank you, body. Thank you, Mr. Chairman.
And Mr. Robbins, you want to carry over 238 concerning something about civil procedure and filing of judgments, right? All right, we will do so. Ladies and gentlemen, this brings us down to the last thing we're going to do this afternoon, and that is a public hearing on House Bill 319. House Bill 319 is Representative Drummond's bill. I have 4 people who have asked to speak in favor and 4 people in opposition. We're going to let all of you do so. There will be no vote taken on this bill today. No vote taken on it today. We will carry it over and hopefully have a vote on it next week. Okay? But Ms. Drummond, why don't you tell us a little bit about this bill before we turn it over to our individuals who wish to speak.
Good afternoon, Mr. Chair and committee members. Just a little bit, I can't.
Ms. Drummond, you can tell us all you want to tell us. I'm sorry, I'm going to tell you like I always do my preacher. You can talk as long as you want to. However, after about
I'm a Baptist,
minutes,
so that may be a while.
After about 15 minutes, it's hard to keep listening.
But no, I won't take that long. But I want to thank you all for the opportunity this afternoon. And I also, Mr. Chair, if we have any questions, I wanted you to know, and I'm real pleased that I've got ABC with me, Aaliyah, and also I think the Also, the Alabama Revenue Commissioner's Office is here as well as a number of folks who will speak at the public hearing. But I wanted to tell everybody, especially the new members who are on this committee, because this has been almost like having an apple, and I've had to bite a little bit at a little bit. And as you all know, sitting in this body that we call the Alabama Legislature, you don't always get everything that you want. So you bite at the apple one piece at a time. So I wanted to, I sit back on last evening and I start talking about the evolution of vaping, and it is in my heart. And one of the young ladies who's here with me today is from Mobile, and she's the executive director of our Drug Education Council, which covers a number of counties in South Alabama. But she had us at a meeting and she talked about vaping. And I wanted you all to know that as a person who stands here today who has lost a mom to heart disease and a dad to stage 4 cancer, these issues are very, very near and dear to me, especially as it relates to young people. I started this journey on vaping with Representative Stringer in 2019, and I thought that that was going to be the last time that I would have to do that after sitting into Virginia Guy's office and being said, we've got to do something about this problem. Well, that wasn't the last bite at the apple. I realized that we're in a body where you have to compromise. So in 2021, I passed, and I thank God for former President Trump, because he had FDA pass a registry on vaping, which we adopted here in Alabama. And I worked very hard on that. And I took another little bite of the apple because I was fighting on behalf of young people in the state of Alabama. This time, the apple is getting larger. I would stand here as I did a couple of weeks ago and say this bill is an easy bill. It's an easy bill for us to make a decision on, but there are a lot of pieces of this apple. So I wanted to tell the new members kind of how this apple came together. Senator Garland Gudger and I have been working 9 months on this piece of legislation. And we brought everybody who would have an interest to the table. Did we all get everything that we want? No. Just as you all know, because you've had pieces of legislation, there's no perfect bills out here. But one thing that I did get that I think is so important, the registry, the Department of Revenue has done an excellent job in putting together the registry. And we gave them walking orders and orders to go out and stop vaping in the state of Alabama. But we didn't give them a whole lot of resources. Vaping is so important. We regulate nicotine, but we don't regulate vaping in the state of Alabama. What my bill will do, House Bill 319, this bill identifies the products that not only contains nicotine, but it also includes those that include e-liquids and e-liquid substitute. It will regulate e-liquid in the state of Alabama. But to break it down, the bill has a lot of components that I think that are very, very important. And I want the committee to know when we come back next week, we've got several amendments. So as I talk, I will tell you where we will be putting those amendments. This bill will simply now create a mechanism by which ABC and ALEA can now go out and enforce the laws that we have put on the books, especially the registry. What is happening in the state of Alabama is that there are a lot of bad actors out there. We see a lot of stuff on the vape shelves when we go into convenience stores and other stores that should not be sold because they're not even on the registry. But we're not enforcing that law right now. It's time that we stand up for our children. And I'm tired of biting at this apple, so I put a lot into this bill. Another component of the bill, it will create for ABC with fees of about $50 an application fee and a permit fee of $150. We have that will probably be about 8,000 permit holders. They will pay that fee. Those funds will go to ABC and ALEA. When you look down into the bill, we've created also penalties because it is time that if you go to a school sitting right out in front of you And this was found at a third grader, by a third grader. If you see these, they look like highlighters, something you would have on your desk. And I was told by the educator that the kid just leaned over and was vaping right out in front, inside of them. What is happening in the state of Alabama, not only at schools, but in other places where foster children and vulnerable population, they're using these things. And we're sitting here saying that, I told somebody the other day, the reason I keep biting at this apple because I can't give up. Doing nothing is not an option. We've got to continue the fight for vaping because vaping is not good. I got a call this past summer, and it broke my heart when a young man in Selma, somebody laced his vape pipe with just a little bit of fentanyl. He died. Miss Guy called me and told me about some students at Baker High School. They didn't die, thankfully, but they got very sick. So I kept saying to myself when I brought this piece of legislation, I am so tired of vaping. Y'all, as my colleagues, it's time for us to step up. And when you look at what we have in this law, the only thing that will be changing, we won't be taking any driver's license away. We're now working with the Board of Education. There will be a penalty phase, and I'm so pleased to announce that the Board of Education has announced that penalty money that we will have from this piece of legislation will now create vape classes for all of our middle and high school students. That will be a part of their penalty process. They will still have to pay the $200, but that's only on your third offense. You get a number of times that you don't have to. And then it will also include that parents go to those vape classes, because what we find is that a lot of times kids are vaping because their parents are vaping. And in the city of Talladega, they turned their vape problem around by having the resource officer do comprehensive vape classes for those that violate. They have seen their vaping problem go down by 67%. That's what this bill will do. It will create mechanism for funding for the problem. It will give ABC and ALEA the enforcement power that they need to help us stop this problem. And it will send a penalty part not only to the violators of the convenience stores who sell these products to our young people, but it will also show young people we're not going to tolerate this. Because when I sat at the table, I told Judge Hill this. I wish I could just ban it all and none of it could be sold. But I know that that would not work. There are a lot of small businesses out there. And they came to the table and they worked in good faith with Senator Gudger and I. That's what this compromise piece of legislation is. And so I thank you this afternoon. If you have any questions, I'm more than happy to answer.
Yeah, go ahead, Mr. Stringer. Now, I want you to understand, we're going to have her back up here in a week. I'm going to let you can certainly ask her something today, but in a week, we're going to have her back so that we can consider this, but go ahead.
Yeah, I'll make it short, sweet. First, I wanted to kind of check my hearing. You said you thank President Trump for his efforts in the, I'll take that as a yes, thank you. All right.
Well, let me just say this. I thank you for being in this fight with me because you started this. The first vape bill in the state of Alabama is entitled the Stringer-Drummond Act.
Yes, ma'am.
And we thought the apple was through then, but we had to come back with another one. And you sort of left me on this journey by yourself. And I'm a girl. When you go to the party with me, you need to continue to dance with me.
I like that. Hey, I just had a couple of questions, and you and I have already talked about some of this, and I'm not going to go over too much, but one thing I did have a kind of concern with was the punishment on the children. I think it's got in there on the age that we're going to punish them was from 18 to 21, is that correct?
You will see when you see the amendment, that's going to be a part of the amendment. We have broken that up, but 18 to 21, you cannot punish them the same as you do a third grader. So you will see levels when we bring the amendment, and we'll get that amendment to you very soon. We work in concert with the Board of Education. Again, this has been a compromise piece of legislation
Yep, and I that was one of my concerns. The other was the $200. That's a lot for a young person.
Well, Mr. Representative Stringer, you know that these products, they don't cost a nickel, they don't cost a dime. They're very expensive. If you've ever gone into a service station, fortunately, I don't have to go buy mine. All of those folks who confiscate theirs, they call Representative Drummond from private schools to public schools to those that are taking care of foster and vulnerable population of children. These are not cheap. We've got to send a punitive measure to those that we can. As you saw, you know, at first, some of us wanted language to take away driver's license. We're changing all of that because the third grader doesn't drive. And you will see a third grader won't have to pay that $200, but there are punitive measures. You will see that in the amendment that they will also have to face.
All right. And the other, in your opening statement there, you're saying, is the ABC board not enforcing or regulating the businesses now?
They are, and I apologize to them. And I think you probably will, because when we first started this journey, I was very naive. I thought ABC is already in a convenience store. All they got to go and do is look at it. It takes a lot of training. When you see in this bill, we're also giving some resources to the schools because the schools don't know when fentanyl is in here because they don't have the money to go do testing. ABC only goes in and look at a cigarette stamp. But there are no stamps on these devices, especially those that are shipped from China and Mexico. So it's going to be a lot more training. They have to be trained on what those devices are. As you know, those change periodically.
Yeah, and I appreciate your answering my questions and your passion for what you're doing and where you're going with this. And that's all.
Well, it's in the heart, and it's all for young people. You know, this summer, I got more calls than I care to think about, but the young man who died in Selma really pricked my heart. And when it came close to my hometown at one of our high schools, we've got to stand up for the children, for the future.
Yeah, and I agree. And as you know, my wife's an educator, assistant principal, and I hear it every day on what they're dealing with and going, so I appreciate you.
Mr. Carter, you got a question?
Representative Drummond, I appreciate you. You know, we're going to talk about this. I've met with some folks, and you've already mentioned that you're addressing some of the concerns with regard to the penalties on the children. And I look forward to getting with you, meeting with you on these other possible changes to the bill. Thank you for your hard work on this. As you know, I was trying to carry this effort a long time ago, and two of my colleagues named the bill after them. I don't know who that was, but I look forward to working with you on these changes, possible changes, and I've got to step out to pass a bill in the Senate, but look forward to hearing from the people that I can.
Okay, thank you.
Thank you. We got four people, 4 proponents, 4 opponents. What I'm going to ask you to do, we're going to time you. I'm going to ask you to speak about 3 minutes each. So be thinking about what you're going to say, please. We're going to start, and let's do this. Let's run through. Let's go ahead and let everybody speak, and then let's bring back any of them that the committee wishes to question, okay? So, Mr. Green, Blount County School Superintendent, please. He is a proponent of this legislation.
Thank you, Mr. Chairman, and thank you, representatives on the Judiciary Committee. I am Rodney Green, Superintendent of Blount County Schools, and I am speaking on behalf of the bill and the amendments that have been discussed. I think that will be important to the process of this. Vaping in our schools, and what I see in Blount County, is one of the major problems that we're facing right now. It's become epidemic, starting with about 4th grade. We've seen cases in 4th grade on buses. We see vaping in our hallways, in our restrooms. It's very difficult to catch. Kids think it's harmless because they see many around them doing that, and we don't see cans of snuff anymore, or tobacco, or chewing tobacco. We don't collect packs of cigarettes anymore. It's all electronic. And they range from devices that we first started seeing as vapes, now to flash drives, highlighters, it's already been mentioned. Also, various kinds of other devices like dab pens, where they can, and a lot more slender than this ink pen, where they can just raise their lapel and take a hit. We've had 2 instances in Blount County this year off of dab pens that were filled with THC. And they were given to another student that was not accustomed to taking hits off of that, and 2 of those students severely sick, had to be hospitalized, went through some treatment, made them deathly sick. We were fortunate that both of them are okay, but that's what's going on in our schools across our state, and they can look a lot like an asthma inhaler. There's even hoodies out right now that have the string that comes around this way that you can take a hit off of the end of this. It looks like the end of the pull string. And so it's very difficult. We don't know some of these substances that are inside those vapes. Some of them have nicotine. Some of them have THC, some of them don't. Some of them just have pleasant, fruity flavors like blueberry and raspberry. Some of them are called Northern Lights. Cloud 8 makes one. It's a THC base. It's called Northern Lights. One's called Pineapple Express, Juicy Bar that's blueberry and raspberry, and there's a Raz Ice that's a very popular vape right now. For us in Blount County, what we've done is we've passed a new board policy, and that board policy includes a first offense is a 2-day in-school suspension filled with 3 educational modules, because we want to keep them in school if we can, about the harmful effects of vaping and nicotine, and especially THC, and the possibility of fentanyl. After that, if they come back on a second offense, they go to alternative school, but they have to attend a Saturday school being taught by a professional, and the parents have to come with them, and parents have to sign off that they've received this education along with their student. And a third offense is a board hearing. We've not placed anything punitive as far as monetary fees. We're trying to address it with education, but it's such an issue that we feel like we're having to take additional steps. And I certainly would be, and I feel like our superintendents across our state feel like we need to do something, because we don't see regulation out in the convenience stores. It's prevalent. Thank you for your consideration.
Mr. Green, thank you. We have an opponent, Mr. Conley. Mr. Conley.
Chairman and members of the committee, thank you so much for hearing from me. My name is Gregory Conley. I currently serve as the Director of Legislative Affairs for a national trade group called the American Vapor Manufacturers Association. I'm an attorney and have been active in the industry and FDA regulation for over a decade, so the PMTA topic is one I know very well. And I'm here today to urge you to oppose HB 319, because as written, it would do nothing to fix the problems caused by 2021's HB 273, which has fueled a gray market in this state, threatens to shut down Alabama's vape specialty stores, none of whom have been consulted nor are going to be on the board created by this legislation. And it would also, for some reason, give unexplainable deference to the actions of Joe Biden's Food and Drug Administration. It was never President Trump that proposed the PMTA registry, let's be clear. There are 674,000 adult smokers still in the state of Alabama, and Public Health England, the Royal College of Physicians, say these products are at least 95% less hazardous than smoking. We need to strictly enforce Tobacco 21, send more agents into vape stores, convenience stores, et cetera. But this proposal, in combination with what you are amending, the 2019 proposal, is a disaster. And the position I'm in today is not one I like to be in. I don't like to come to legislators and say, what you did 2 years ago is bad, because I should have been here 2 years ago to tell you that. But you were still at the end stage of COVID. People were not traveling. It was not easy to do cross-country traveling. And many of the vape shop owners were stuck running their own stores because they couldn't get employees at that time. So 3 parts of this package, and I won't be able to get to all 3, are very bad. The synthetic nicotine ban, which is passed in 2021, the PMTA registration, passed in 2021, and you're strengthening it, and the marketing restrictions. With synthetic nicotine, easy to understand why in 2021, that was a scary word. Nicotine created in a lab, what the heck could that be? Well, 2 years later, the FDA, through Congress, is now regulating synthetic nicotine products. That's a multi-billion-dollar industry in America, legal in 49 states except Alabama, and coming in on the drive, I saw plenty of stores still selling. The science has come in showing that the synthetic nicotine product is no different than the tobacco-derived nicotine taken from the tobacco plant. The only difference is the tiny, minuscule amounts of carcinogens that are present because of the tobacco plant. They're eliminated in the synthetic products. So again, those applications are before the FDA. So in the PMTA registry, I'll just break down a couple myths. Not a President Trump initiative. Will not ban dab pens. Will not stop drug dealers from selling illicit products on the street. Those illicit products aren't being sold in vape shops. And there's a reason why every state that has considered a PMTA registry since 2021, including Georgia and Tennessee, has killed the bill because it is a disaster. You're giving undue deference to Joe Biden's FDA, which is banning these products. The Fifth Circuit Court of Appeals has already said that the FDA is acting politicized manner that is violating the Administrative Procedures Law, and as well, the money involved. You cannot police every store in this state with 100 grand, 150 grand. the Alabama Department of Health receives $16 million, has received over the last decade from the FDA to do youth enforcement checks at convenience stores, gas stations, vape shops. $150,000 if you keep these permit fees, that's not going to do it. You're just going to have the good vape shops that have the easy target on their back because vape is in their name. They're going to shut down, the ones serving the adult smokers who need an alternative. But every convenience store, tobacco shop, they're still going to be selling these products. They're just going to bring in smaller amounts from out of state. And the last thing I will note, one of the goals, I think, with vaping that I think even legislators who have some problems with it would agree is that you want people to get off of nicotine eventually. But this bill will ban all nicotine-free vaping products because you're saying if the FDA doesn't regulate it, you can't sell it. Well, the problem is the FDA only has regulatory authority over products containing nicotine. So you're also just banning every nicotine-free product as well. I have gone over my time. I hope I will get some questions, and thank you so much for allowing me to abuse the time limit. Thank you.
Mr. Chairman, committee members, thank you all for having me. I'm Michael Smith. I'm the CEO for the Alabama Sheriff's Youth Ranches. I have the privilege of serving 51 young people throughout the state of Alabama that wouldn't have a home without us right now, and it's great. We have a problem. It is an epidemic. We have a problem with vape products. We've covered that with nicotine. Is nicotine our biggest problem? No, I don't think so. We have a problem going on at school. Superintendent Green, thank you for what you said. And by the way, Ms. Drummond, I do want to dance with you. We got this because we got to do something to help our young people. Because now what's going on at schools, I'm sure the superintendent can attest to this, they're doing trades at school. They're getting these different products. They're handling this vape device, period, is bad for youth. They're trading it. Our slogan, it's easier to build boys and girls than to repair men and women. Well, help us to build these boys and girls. There has to be a punishment. If you're going to bring vape from home that's got THC in it, Delta 8, whatever you want to call it. I just had one with Delta 8 that the guy, it was his first time. We mentioned we had somebody who was new to it. They hit that Delta 8 the first time and they start smoking on that and puffing on it. They go nuts. It's like being drunk on 2 6-packs of beer. And they do crazy things. And you have to punish these young people that do that. Do we have to make it severe? No. Does it have to be expensive? No. They can serve. Our children at the ranches, they have to do chores. What's wrong with that? What's wrong with community service? The in-school suspension is wonderful. I wish we could get everybody doing what you're doing, because some of the school systems that we serve right now, they suspend the kids. Well, that's vacation. And what about the working parents that are out there, not just the folks we have taking care of all of our young people? We give a darn about these young people. We have to make the penalties severe enough that they will not continue to barter these products at school. Maybe they're getting it from their parents. We had one young man deathly sick because he got a bad vape, they call it, where somebody tried to restore a vape with some stuff in it that he didn't know what he was doing. We had 3 girls in Colbert County, went to a party, guy bought some vape. Next thing you know, our girls are being pulled over for DUI. And they had no idea that they were doing anything like this. And I really believe that with this young ladies. So we have got to make a difference. And the product itself is a problem in youth hands. If you're 21 and trying to get over smoking, have at it. Let's have at it. You can make your own decision. But a 4th grader, 5th grader, 6th grader, they can't make those decisions. So we have to do something. So I'm here. I'm a servant to those young people, and we want to build these boys and girls to be better, and we need your help to make sure these products are not available for our kids. I know the ABC board, know some of those, they'll take care of their business. I'm having more trouble with the bartering at school. I don't know if you feel that or not from your school. So I appreciate anything that we can do to stop this epidemic with these young people. It's our single biggest problem at the Alabama Sheriff's Youth Ranches. Thank you.
I appreciate y'all's time this afternoon. That was interesting, the comment that the sheriff made about if you're 21 and above, have at it. My stores are 21 and above, and that is very serious to us. I know every one of my customers, nearly every one of my customers that comes in, they've been long-time customers getting off cigarettes. That is a very big deal to us. That's why we started our vaping business. I was up to 7 stores. I now have 2 in the state of Alabama. COVID was not kind, but we still want to help people. I'm going to get back to my notes, if y'all don't mind. When I was a smoker, I bought my cigarettes at the Quick Marts and the grocery stores. This bill gives petroleum lobby, that's what I call big oil, and the grocery lobby a seat on the board to make regulations over my business. Big oil is notorious for being the mouthpiece for big tobacco. I have witnessed this myself in other legislative committee meetings in other states. If you go to the FDA's official website under tobacco control and pull up vaping violations, you will be shocked and all you got to do is click on the state of Alabama. Well over 200 violations the last year recorded, with only 2 being in vape shops. Since 2018, there's over 340 violations, with only 3 violations being vape shops. We are 21 and above. The registry has me hung up, makes me illegal if they're to enforce it. The registry that's on the book from HB 273, that's already Alabama 453. That's the end of me. The nicotine, they're calling it synthetic nicotine. It's to TFN. That absolutely shuts me down for no reason. Alabama's the only state that's doing this. I got to help people. And we have to get together and make reasonable rules, not this. This is made from someone that has held a stick up here and showed you something that said it was expensive. That stick is about $8. That's not expensive. Things that would work, I always like to present the good side. What we're not going to do is a nicotine cap. That would solve a whole lot of problems, but that's not going to happen in the United States. That's been in Europe for 10 years. They don't have any of the problems that we're having now, but that's not going to happen. A sensible legislation could be ban all vape shops within 100 miles, or 100 yards of a school, 1,000 yards of a school. That's sensible regulation. Fine the parents, not the kids. I think that's way too much. And if you leave the 21 plus mom and pop shops alone, I can be happy with some of it. But this legislation needs to be completely back to the drawing board, and somebody that does have an interest in what is in the best for the state of Alabama. My customers are moms and dads, grandmas. My average customer is a 50-year-old lady. Our customers are first responders, nurses, legislators' wives, and we're only 21 and above. And that's my main part of my message. And I think Ms. Drummond said it herself when she said, I think I heard the word convenience store at least 4 times, if not more. Not one mention of the word vape shop. I mean what I say. Thank you.
Thank you, Mr. Chairman, members of the committee. My name is Vic Wilson. I'm the Executive Director for the Council for Leaders in Alabama Schools. I represent 1,440 principals, 1,410 assistant principals around the state. Number one problem they're dealing with is vapes, okay? Talking about 18-year-olds and below, kids in schools. That's who we're talking about. It's a big issue. This bill will help make our schools safer and healthier. That's about all I need to say. Thank you very much.
Kirschberg, sir. It's pronounced Kirschberg. Thank you. That was a valiant effort. Thank you. I appreciate it. My name is Philip Kirschberg. I am here from Birmingham, Alabama. I am a former smoker of 20 years. I quit. Never thought I would. 13 years ago, it was April 21st, 13 years ago this year, that I quit smoking cigarettes. I am 48 years old. I want you to know that I exist. Hi, I'm right here. I've heard a lot about everything from adulterated vape pens to carcinogens in these products. I've not heard anything about the impact that it's had for people who smoke, adult smokers. People like me have been using these products to live better, healthier lives for well over a decade. I have truly never known anything like it. And I promise you, there's something about the way in which these facts have been presented that I really won't get into, but let's just say I come from a family of physicians. These products aren't causing cancer and they're not killing anyone. These are actually displacing cigarettes. No one is talking about how few of our youth are smoking. In 2010, I believe youth smoking in this state was somewhere around 8 to 20%. It's now down to 7%. When I graduated high school in '93, 47% of high school seniors were smoking. Please, this is a very passionate topic. My heart goes out to Ms. Representative Drummond for the person that she lost, but we've lost a lot of people too. My grandfather died at 74 from complications due to smoking cigarettes. Mr. England, you talked about unintended consequences earlier very eloquently. This will have the unintended consequence of, well, it could very well give young people records and ruin their lives beforehand, before they even get started. But the unintended consequences here are final, because I have recently had to get my product of choice from a friend in Tennessee because it has been pulled from the shelf here after a letter from R.J. Reynolds Tobacco Company went to my preferred vape shop, and the next day the ABC board walked in for an inspection. Yes, that's a wild coincidence, I know. But what I want to leave you with is that no one wants young people smoking or vaping, but the very uncomfortable fact is that it might be the least harmful thing that they shouldn't be experimenting with. So if we could please calm down for just a moment and think about how much good these products can do when properly. We have laws on the books. 21, all the shops that I know enforce the age restrictions. No kids are coming in there, and there is no epidemic per Brian King, head of the Centers for Tobacco Products at the FDA. Youth vaping is way down. So I'm asking you to please think about the adults that these products have significantly changed lives. They have truly changed my life. I never thought I would quit smoking. I was resigned to die a smoker. And don't send people back to smoking, which is, if we've all forgotten, the deadliest consumer product in history. We're making progress here. Please, let's not stunt it with ill thought out restrictions that are really very possibly going to shut down many small businesses. But I wanted to speak to you as someone who has benefited. I can't tell you what this has done to change my life, but there are so many others out there. 17% of adults in Alabama still smoke cigarettes, and most of them are our most disadvantaged citizens, people of lower middle income status, and they are still smoking, and they're hearing a lot of things that just aren't true about these products. Please don't take that chance that they have to switch to something that will enable them to live longer, healthier lives.
Thank you, Mr. Kirschberg. Let me ask you something. You're on this that you signed up. It looks like you've got organization BEAA. Can you tell me what that is?
That's the Breathe Easier Alliance of Alabama.
Okay.
I give them $25 a year. They're probably very upset with me.
It's okay, Mr. I just didn't know what it was, Mr. Kirschberg, and I want to understand, where everybody's coming from.
No, I appreciate that.
Thank you, sir. Appreciate it. Mr. Howard?
Thank you.
Thank you, Mr. Chairman and committee, for allowing us to come and discuss this very important issue with you. I am from Mobile, Alabama, and I worked for the school district there for almost 40 years. I just retired. I now work for the Drug Education Council there in Mobile, and I brought with me my director and several of my coworkers. I was a resource officer, and in that 40-year period of time, I have seen more recently vaping become a greater issue and a greater concern. And as a resource officer, what we did is we worked in a proactive way to try to deal with the issues of vaping after it became a problem and somebody got in trouble. This year, the Mobile County Public School System disciplined so far about 1,200 kids for vaping. I think that's a fraction of the people who are misusing vape on school campuses. Those are the ones we caught. Also, recognize it's probably just a fraction of the children who are engaged with vaping beyond the school campus. When I was being proactive, I was doing the discipline part. This week, Monday and Tuesday, I went to an elementary school. I think it's in your district, Mr. Stringer, and I talked to a couple of hundred kids. And this fifth grader, Kendall, and this fifth grader, Michael, said to me, when I said where I was coming today, Kendall said, would you please ask them to regulate vaping? She's 11. Michael said the same thing. They think that it's not okay. He said, I'm sorry, I'm not going to try your name. He said the least harmful. My problem is it's harmful. And what Kendall and Michael want you to do is keep harmful things from being a part of their experience and the experience of their peers. And so what we want to do is just ask you, and I'm speaking on behalf of today, on behalf of the Mobile County Public School System and Superintendent Threadgill, who asked me to come up here because they know I've seen both sides of this conversation, to speak to you all about, please, regulate it. Make it not that easy for people to misuse it. Last year, I saw a young man who hit a THC vape pipe 3 times on a school bus and tried to climb out of the bus window while it was traveling. The children held him partially out of the window until they got to a building and were able to get him out of that window. He didn't even remember what happened to him the following day. To say it's least harmful, I'd rather it not be harmful at all. And I understand the idea about the cessation from tobacco. I saw my grandfather have respiratory issues from smoking a pipe. I saw my father have respiratory issues from smoking cigarettes. And what I saw was that was something I didn't want to do. So I told you Kendall and Michael. So my conversation with Michael was this. Some people can see the light, and we're going to continue to try to teach them to stop doing it. And that's why they change. Some people have to feel the heat, and it needs to be regulated. We need both, for them to see the light and feel the heat, and the spill controls that. Thank you.
Thank you, Mr. Howard. Mr. Roundy, is that correct?
That's correct.
Please.
Thank you all for your time today and allowing me to speak. I've been a vape shop owner since 2015. I started my company when I was 25. We hear a lot of talk about protecting children. There was no protection for my generation. We had DARE, we had promises, we had means to try to stop it, and it didn't exist. I lost my father-in-law due to COPD complications. He died locking his front door. And I started vaping to find a means for myself to quit because there weren't any others. I also have children in my home, and I think a lot of that takes parents taking part in their children's lives. My 16-year-old has no intention to vape, has no desire, comes home to me and does tell me about the children that are in the bathroom vaping. But I think there's a difference in what's taking place at home and how these kids are getting access to it. None of the provisions inside this bill protect any of what you were trying to protect. They can get on TikTok and find someone to buy this from. They can go to dhgate.com. You can buy a box of Elf bars for $42. It's a knockoff cloned product. It's not a legitimate product at all, but you can get it for $42. And that bypasses customs, beats the FDA on a regular basis. All this law will do is restrict my ability to legally sell proven safer products to the general public that are of age. We've been 19 plus before the 21 and up increasements by the federal government. We followed those laws prior to Alabama even having something on record to follow tobacco law against vapor. One of the products I believe Representative Drummond's brought up was, I believe it was a puff bar or a pod bar. Those are already banned by the FDA. They were already removed. They're not supposed to be on the market. That wouldn't be a product that would be found in my store. We work off of the FDA's database very clearly. The ban on synthetic nicotine was a massive failure. The FDA saw an opportunity, saw the science that was there, and gave a pathway for those products to be submitted and go through the exact same process as our traditional PMTA, and gave us an additional time frame to do so because they saw the potential gain that could be gathered from that. We've completely stripped that from our state. I agree that convenience stores and easy access should be eliminated. I think all of our products should be 21 and up. And an adult environment inside my store, you can't bring a child inside of it. We have a drive-through available for adults that might be trapped with their child or, can't make it through, but they have the option. There's ways of getting around, putting them inside the store and seeing all of these products. I truly feel like we need to find a balance between what's taking place and the ongoing scientific research that's showing. The FDA has now been proven now with FOIA documents from the AVM that they lied during these processes. Instead of opening multiple stores, I wasted $250,000 registering my product, filing with them, testing my liquids, all to be told that I couldn't provide a psychological study that a child wouldn't use the product versus an adult in my store, which we didn't allow the child to begin with. So all of that effort went for nothing. Sorry, there's a lot of points that have already been spoken over. I believe that's really all I have to offer from everyone.
Thank you, Mr. Ryan. We appreciate it. Ladies and gentlemen on the committee, do any of you have any questions for the individuals who have just spoken to us? If so, we will call that person back up. Okay, Ms. Drummond?
I want to remind the committee, I've listened, this is not a tobacco bill, it is a vape bill. And from day one, when I started this journey in 2019, my desire is not to put anybody out of business, but this is a vape bill and one that is geared to young people. So I would hope that the committee would keep that in mind when looking at this. And I certainly thank you for the opportunity. If there are any questions of me, I'm pleased to answer.
Well, Ms. Drellin, you'll be back next week. I understand you got some amendments.
Yes,
we will
sir.
certainly take those up in our committee hearing. Seeing nothing further, we stand adjourned.
Thank you.
you.